Good morning, everyone, and thank you for joining us for today's OCSS Training Institute presentation, Child Support Information for Active Duty and Veteran Members of the U.S. Armed Forces. So, at OCSS, our services, and in essence, our mission statement, is that we put children first. We help both parents support their children. We do this by locating NCPs and establishing parentage when necessary. We then establish child and medical support orders. Those are done in family court in front of a support magistrate that deals only with child support related issues. We then go about dispersing, monitoring, and enforcing those orders. And we help NCPs to find employment and also to avoid and manage debt. And we will be talking more about debt management opportunities later in this presentation. There are a lot of benefits to child support. Legal parentage is established, giving the NCP a say in the child's future. It also means that regular payments based on the NCP's income are made by the NCP to the custodial parent. There's formal documentation of financial support. Collections are enforced by OCSS. And most importantly, and central to our belief, is that the cost of raising a child is shared by both parents. And regardless of how that child came into the world, whether it was the child was a product of a marriage that soured at some point in time, or if the child came about through a very casual, short-term relationship, regardless, it is the responsibility of both parents of a child to be supportive of that child, both monetarily as well as emotionally. Studies show that child support improves outcomes for families. It provides the custodial parent with financial stability. We do the record keepings to prevent any disagreements. You didn't pay me last month. Yes, I did. No, you didn't. That sort of thing. And we make sure that the child has medical and, if necessary, child care support. And child support also gives NCPs a voice in their children's future, greater opportunity to engage with their children, and motivation to find and keep employment. For children, studies show that their children receiving child support are more likely to complete school, exhibit increased self-control, and show improvement on many other social indicators as well. We believe that by helping children receive the support they need, as well as working with parents to reduce financial stress, we can, through the generations, break the cycle of poverty that has families ensnared. Now, there are special concerns for veterans. Some veterans may have high child support debt. Child support debt can contribute to barriers for veterans seeking to secure housing and employment. And homeless veterans are often transient and less likely to live in the state where a child support case was initiated. So we're aware of these particular issues. Now, there are some special protections for the military, principally the Service Members Civil Relief Act, SCRA. It's a federal law that protects uniformed service members. They can have protection from default orders and can pause proceedings and garnishments. This protection is primarily for active duty service members or veterans upon return from active duty or those that reenlist. Now, we know some of the veterans that are on our caseload. We don't know all of the veterans that are on our caseload, but based on our records, we have 6,259 veteran child support cases in New York City. 65% of those, the veteran is the non-custodial parent. 34%, the veteran is the custodial parent, and 1%, both the custodial parent and the non-custodial parent are veterans. The numbers of the total number of veterans on our caseload is probably higher. We do not have a mandatory question regarding, are you a veteran? So likely there are many more veteran child support cases on our caseload. So the average monthly obligation amount for veteran NCPs is $269, and the average amount veterans have paid over the life of a child support case is in excess of $32,000. So veterans pay child support just like other non-custodial parents who aren't veterans. Now, enforcement for military is a little different from the average child support case. Subject to income withholding, as is the case with any non-custodial parent who has a regular job, we can withhold from military active duty pay, military pensions and retirement pay, and Veteran Affairs benefits, with the exception that if the veteran waives their retirement benefits to get disability benefits, then we don't collect from those benefits. So when determining income for child support purposes, state guidelines consider all income, and for military members, that includes base pay, any special skills pay, bonuses and allowances, such as basic allowance for housing and basic allowance for subsistence. Those, BAH and BAS, are not subject to income withholding. When enforcing the child support order, active duty pay, pensions, and VA benefits are subject to garnishment. Child support works with automatic processes that alert the organization to these forms of income through communication using internal and external databases. Basic allowance for housing and subsistence and veterans assistance for low-income individuals. In addition, veterans' disability pensions are not usually for child support. The exception to that being if a veteran waives part of their retirement benefits to get disability benefits, then part of their veteran's disability benefit that is substituting for retirement benefits can be garnished for child support. Now, we have a special case review program for veterans and active military. This means you have the opportunity to meet with a customer service representative by phone or in person to review your child support case and ask questions. You can schedule an appointment by emailing that long email address. And by the way, we're going to distribute this presentation to all of you who are in attendance tomorrow or Friday at the latest. And everything underlined in blue is clickable, so you'll be able to use this link if you want to schedule an appointment. You email us, enter AF case review in the subject line of the email, and provide your case ID, name, and date of birth. We're going to hold special case review sessions for veterans and active duty military personnel on Tuesday, November 18th and Wednesday, November 19th. As I mentioned, these can be conducted either by phone or in person at 151 West Broadway, 4th floor in Lower Manhattan. At these sessions, parents will have the opportunity to meet with a customer service representative to review all aspects of their case and learn about resources and programs that may be available to them. Parents can walk into our 151 West Broadway office on those days or schedule a phone appointment by sending an email to that long email address. And as I said before, write AF case review in the subject line and include the full name and child support case ID in the body of the email. Now, this morning, we have the pleasure of having our Assistant Deputy Commissioner of OCSS for Community Engagement, Alan Farrell, with us. Alan, would you like to make a comment on the case review sessions at this point?
Good morning, everyone. Thank you so much, Chuck, for this wonderful presentation so far, and for the opportunity to share this information and to speak to those in attendance this morning. Again, my name is Alan Farrell. I'm Assistant Deputy Commissioner for Parent and Community Engagement here in New York City Human Resources Office of Child Support Services in the Parent and Community Engagement Division. And as Chuck has just described, yes, we are looking forward to these case review sessions on Tuesday, November 18th, Tuesday, November 19th. We did this last year and maybe even the year before. So we're trying to do this every year during this Veterans and Active Military Month in November, either around or soon after Veterans Day. And the beautiful thing about this is that, yes, we are going to be focusing on serving our veterans and active military, but also it's important to note that the opportunity to request and participate in a phone appointment is something that we've actually been offering since after the pandemic. Used to be you had to walk into 151 West Broadway, and that was the only option. Now you can walk in to 151 West Broadway on the fourth floor at any time. I guess actually between, I think it's 8 and 6, or should I say 9 and 6, I should say, between 9 a.m. and 6 p.m. I think someone asked in the chat. So you can walk in and do that, or you can use the email and request a phone appointment. And so we certainly look forward to you participating. Please share this with your colleagues if you serve the veterans or active military, or certainly those that you may have served with or that you know are veterans and that could benefit from this resource. Thanks again, Chuck, and look forward to working with everyone.
Thank you, Alan. And by the way, somebody put a question in the chat with regard to the hours, as Alan indicated, 9 to 6. Feel free to put questions in the chat. We are going to have a Q&A session after we're done with the presentation, and we will address the questions in chat first. Now, apportionment is a separate issue that is not a child support action. Under certain circumstances, the Veterans Administration will send a portion of a veteran's benefit to a dependent without a court order. And the entities that can ask for an apportionment include a minor child, an estranged spouse, or a dependent parent. So apportionment is a way that a veteran's benefit goes to a dependent without a court order, and it's not officially child support. Now, the life cycle of a child support case can be very lengthy. We open a case when a custodial parent comes to us seeking child support. And the first thing we have to do is establish parentage, or paternity as it used to be called, because there cannot be a child support order unless and until parentage is established. We then go to family court in front of a support magistrate to establish the child support order. And in New York State, the percentage that a non-custodial parent pays is based on a percentage of the NCP's gross income, and it's intended to be a manageable amount. 17% for one child, 25% for two, 29% for three, 31% for four, and at least 35% for five or more children. This is pursuant to a New York state law called the Child Support Standards Act. Other states have different methods and percentages. We then set about collecting and distributing support. And if, for example, a custodial parent files for child support when a child is 3 years old, in New York State, the age of emancipation is 21. It's different in other states, sometimes as low as 17 or 18. But in New York State, the age of emancipation is 21. So if child support begins when the child is 3, that means we're likely to have an 18-year relationship with the custodial parent and the non-custodial parent. So we go about collecting and distributing support and then enforcing, or when necessary, modifying an order. And over the length of a child support case, it's not uncommon for there to be several modifications. If the NCP moves to another job and gets a raise or promotion, that would be grounds for an upward modification. If an NCP loses a job or has their hours cut, that could be reason for a downward modification. Child support is intended to reflect the ability of the non-custodial parent to pay based on who the non-custodial parent is at the time. And obviously, over the span of many years, circumstances are very much likely to change, and we want to adjust the obligation amount to reflect who the non-custodial parent is at the time. Now, I mentioned that in New York State, 21 is the age of emancipation. However, there are instances where a child may emancipate earlier, which would lead to a termination of the order. That would take place if the child becomes financially independent, marries, or joins the military. Also, the child support can be extended beyond the age of 21 in two specific instances. One is if the child goes to college, the support can be extended for up to another 2 years, or if, unfortunately, the child has some kind of serious disability, then child support and is not able to be self-sustaining, child support can be extended for a longer period of time. The two places where debt often becomes a problem is either when the order is established, particularly if the NCP does not participate, or during the time of the order, if we have to enforce because debt is piling up. And we'll talk about that in a little more detail shortly. I mentioned enforcement. There are a lot of administrative enforcement actions that happen automatically based on an NCP falling behind, and they're triggered by our database. We can seize lottery prizes. We can freeze bank accounts and take money from that bank account. We can intercept tax refunds. We can suspend the NCP's driver license. We can, although we're currently not doing it, report the NCP to the credit agencies. There are other administrative enforcement actions as well. On the judicial side, the support magistrate in family court can reduce debt to a money judgment. That comes with interest. The NCP can be ordered to participate in a work program. The support magistrate can suspend professional licenses, such as a doctor, lawyer, or medical license. We can issue an arrest warrant and subject an NCP to incarceration. Now, I want to stress that child support is federally mandated, state supervised, and locally administered. And in New York State, we do not make it a policy to incarcerate non-custodial parents just because they have fallen behind in their payments. We do not incarcerate dead broke non-custodial parents. The people that we go after, and it's perhaps a dozen a year, not a lot, are willful people who are guilty of willful non-payment of child support. The doctor who says, I'm not going to give that no good X amount a penny. You want to take away my driver license? Fine, I'll get a chauffeur. That is willful refusal to pay child support. And that is the kind of individual that we will go after. That's the only kind of individual that we'll go after. So there are a range of enforcement actions available to us. Now, due process requires that the NCP has the right to challenge any and all enforcement actions. And the steps to challenge each action are listed on the warning notice that's sent to the NCP before we take an enforcement action. There is one exception. We do not notify NCPs ahead of time if we're going to freeze their bank account, for the obvious reason that that would lead someone to take the money out of their bank account. Instead, we freeze the account and then notify the NCP. A challenge can be upheld because of a mistake of fact, or the NCP is exempt from the particular administrative action, or it's a mistaken identity. Each challenge for an enforcement action has a specific time frame ranging 10 to 45 days from notification, depending on the action. If the NCP challenges the enforcement action, we review the case and determine if the challenge should be upheld or denied. And then a notice is sent to the NCP reflecting our decision. Nowadays, there are two paths to establish or to modify an order. And I want you to be aware of this because there's an opportunity here. There is the traditional court process. And then in the past few years, we've developed a system where we, OCSS customer service, facilitate agreements rather than go through the traditional court process. Let's take a look at that court process. The traditional process is the NCP receives a summons, summoning the NCP to a hearing in family court. Now, depending on the circumstances, the NCP may be expecting child support to become an issue, or it may come as a complete surprise. There's a hearing in family court once the NCP is properly served. If the NCP does not appear, then the sheriff serves a summons. There may be multiple hearings in family court. There may be a need to return for additional documentation or for the establishment of parentage. There can be a hearing in family court where the request is both for support and a determination of parentage. So that may mean multiple visits to family court, ultimately resulting in a child support order. And once the order is issued, child support is deducted from the paycheck or paid directly by the NCP. The payment goes to our support collection unit, where it's recorded, tracked, and then dispersed to the custodial parent. Now, there are some challenges with the court process. There's uncertainty. It's confusing. Things happen very fast. Family court is crowded. It may require multiple visits. And it's a formal process. You need to dress and behave in a certain way. You do not, by the way, have to be represented by a lawyer. Family court for child support is what's known as a pro se court. You can represent yourself. You can have an attorney if you wish to. Most people don't. But again, it's a formal process. There aren't a lot of opportunities to ask questions or to get explanations. With agreements, the parent or parents and OCSS fill out the agreement together. And I want to stress the amount of child support that the non-custodial parent will be expected to pay will be the same in the agreement process as it is if as it would be in the traditional process in court. So the amount is the same. The parents fill out the agreement together. They can work with customer service together, or if the relationship is not good, they can um, uh, work with us separately. The agreement is reviewed by an attorney at no charge in our office, and then it's sent to court, and a hearing is scheduled. Then the parents go to family court, usually for one brief hearing. And by the way, now a lot of family court hearings are being done virtually. So that means you don't have to go down to the courtroom, sit in a crowded court, go through the metal detectors, all of that. In the agreement process, the support magistrate just wants to make sure that the parents entered into the agreement voluntarily and that they understand the agreement, and then the child support order is filed. So this is a much more relaxed process, and you have the benefit of going to court knowing what the outcome will be ahead of time because you've already worked it through with our customer service staff. So the benefits of agreements, the opportunity to ask questions, the order aligned with the NCP's income as it would be in court, shortening the time in court. It's a more supportive process, and it also can lead to open discussions between parents, which may include other topics in addition to the dollar amount of child support. For example, maybe there's agreement about where the child's going to spend birthdays, every other birthday with the other parent, or discussions about how the two parents best communicate. Sometimes the custodial parent objects because the non-custodial parent calls while the custodial parent is trying to put the child to bed, for example. So we can deal with other topics besides just child support in the agreement process. And because it's an agreed upon process, it tends to decrease default orders. A default order is when the court says, oh, the NCP didn't show up. Well, I'm making the child support order X amount. Generally, it's a pretty high amount to encourage the non-custodial parent to come into court and bring proper documentation of their income. So if the idea of an agreement is appealing, to apply, you can email that long email address and put agreements in the subject line and include your contact information in the email. Or you can visit the Customer Service Center in Lower Manhattan at 151 West Broadway on the fourth floor, Monday to Friday, 8 a.m. to 6 p.m. Now, it's important, and I can't stress it. I mentioned it earlier. I want to circle back. The NCP must participate. Participating in the process provides protections for the NCP from day one. If the NCP participates, the child support order is aligned with his or her income. If the NCP is earning below the federal poverty level or the self-support reserve, and we'll talk in more detail about that in a minute, then there are protections in place. And above the self-support reserve, that's when the percentage of income, 17%, 25%, et cetera, comes into play. And ideally, the NCP pays on time and in full, leading to better outcome for the children. There are, as I mentioned earlier, protections for low-income NCPs. If the NCP is earning at or below the federal poverty level, and if you look in the lower right, you'll see that for this year, 2025, the federal poverty level is $15,650. If the NCP is earning at or below the federal poverty level, the NCP is likely to get what's known as a poverty order, $25 a month or less. There's such a thing as a $0 order, and a $500 cap on arrears owed to DSS. Now, we know that it's a little more expensive to live in New York State than in other states. So New York State has evolved what's known as the self-support reserve, which in 2025 is $21,128. If the NCP is earning at or below the New York State self-support reserve, then the NCP can get a minimum order, usually $50 a month. It's above the self-support reserve when the Child Support Standards Act kicks in, and support is a fixed percentage of the NCP's gross income. Now, as I mentioned earlier, there are times when an order needs to be modified, and either party can file a petition to modify an order upward or downward when circumstances change. That could be a new job or a raise, job loss or decreased income, incarceration, a sudden disability, or a change in custody. And in fact, as I said earlier, it's not uncommon for an order to be modified several times during the life cycle of a child support case. If the NCP gets injured and goes on workers' comp, which pays less than a full salary, then that would be reason for a downward modification. If there's a change in custody, not uncommon that a teenage child announces, "Hey, Mom, I'm sick of living with you. I want to go live with Dad." A change in custody could result in the termination of the existing order, and it's possible that the person who was formerly the NCP now becomes the custodial parent, and the person who was the custodial parent now becomes the NCP and pays child support. We know that veterans move around quite a bit. So one of the criteria is if you need to get an order modified, who is the state that's in charge? If any of the parties, NCP, CP, or child, still live in the state that issued the order, only the state that issued the order can modify the order. If none of the parties live in the state that issued the order, the state that issued the order no longer has jurisdiction and cannot modify the order. If none of the parties still live in the state that issued the order, and all of them now live in the same state, the party's new state of residence can assume jurisdiction and modify the order. If none of the parties still live in the state that issued the order, and all of them now live in different states from one another, the parent seeking modification must register the controlling order and petition to modify the order in the other parent's state. So the takeaway here is that the original order controls, but who can modify that order may change based on where the parties live. So, child support debt, and there's quite a bit of it. The average amount of child support debt for veteran NCPs is $24,937, almost $25,000. And we know that child support debt can be a barrier to paying current child support. The NCP says, oh, it's hopeless. Why even try? And that can become a barrier to NCPs engaging with their children. So we have a number of debt reduction programs that can help NCPs manage or eliminate debt. And we're going to look at those now. So for money owed to DSS, we have many programs: arrears cap, arrears credit, pay it off, and the parent success program. And we're going to talk about each of those. And you can learn more by clicking on the link on the right of the screen. Money that's owed directly to the custodial parent can be addressed through mediation. Now, some of you are probably wondering, well, wait a minute, when is money owed to DSS and when is money owed to the custodial parent? That is determined by whether or not the child is currently receiving benefits, such as cash assistance and the like. So when the child on the case is receiving benefits, the payment goes to DSS and a portion of that payment is passed through to the custodial parent. When the child is not receiving benefits, the entire child support payment goes to the custodial parent. So sometimes, and so therefore it's quite common over the life cycle of a case that at some point in time, money is being paid to DSS, and at other points in time, the money is being paid directly to the custodial parent, and it can go back and forth. We have a lot more tools at our disposal to address money that's owed to DSS. With the CP, our only option is mediation. Let's look at the debt reduction programs for money owed to DSS. We have arrears cap that caps arrears at $500 during the period an NCP earns at or below the federal poverty level. Arrears credit provides a $5,000 annual credit for money owed to DSS when child support is paid on time for a full year. This program can be repeated for 3 years for a maximum credit of $15,000. Pay It Off is a limited time payment matching program. Make a payment of $500 or more toward child support debt, and the payment will be matched. So if you make a $500 payment to debt owed to DSS, that will turn into a $1,000 reduction in the amount owed to DSS. There's also the Parent Success Program, which allows up to $7,500 in debt to be eliminated after completing an approved substance use treatment program, or, and this is new, securing a job through an OCSS employment program and staying in that job for at least 3 months. Now, reducing debt works. We have, through the arrears cap program, reduced $292 million in debt over a 15-year period, and we've helped over 14,000 NCPs. Arrears credit has reduced over 88 million in debt and helped over 5,500 NCPs. Pay It Off has reduced 20 million in debt and helped over 4,300 NCPs. And I want to mention Pay It Off is a once-a-year program. This year, the program Pay It Off was held in the first 2 weeks of March, and we are planning to hold Pay It Off next year, 2026, in the first 2 weeks of March. So keep an eye out for that if you owe debt to DSS. So, debt reduction. You can learn more by clicking on the web address on the top right of your screen. You can email us at that long email address. Put debt reduction in the subject line. Include your case ID, name, and date of birth. Or you can visit our customer service center in Lower Manhattan at 151 West Broadway, Monday to Friday, 8 a.m. to 6 p.m. Now, mediation services is the only way that we can help address child support debt owed to custodial parents. We do not have the legal authority to say, Mr. Smith, you owe Miss Jones $50,000 in unpaid child support debt. We're going to reduce that to $10,000. We don't have that option. But mediators can help parents come to agreements about past due child support payments. For example, Ms. Smith, you know Mr. Jones cannot pay you $50,000 in past due, but if he could pay you $3,000 every 6 months for 12 months for a total of $12,000, would you forgive the rest? Maybe that would be a good idea for Ms. Jones. Mediators who are trained can help parents come to agreements about past due child support payments, future child support payments, also issues of custody or visitation, and communication, and other types of conflicts. To apply for mediation, you can email us at that same address with the subject line mediation, including your case ID, name, date of birth. You can click on the link above to get a list of service providers, but we're also going to send you a copy of that list along with the presentation tomorrow or Friday. So you have options. Now, at OCSS, we're trying to improve our communications. We have a lot of YouTube how-to videos. We work at improving our website. And as mentioned, we now schedule customer service appointments by phone, something we started during the pandemic and that we plan to keep going forward. We know that it's a long ride to Lower Manhattan from way out in Queens or the Rockaways. So you can set up a phone appointment and avoid all that travel time. Now, also, I want to call to your attention the Access HRA Child Support mobile app. It's free. It's in both. It's in all formats. You can apply for child support. Both custodial parents and non-custodial parents can submit forms and affidavits, apply for agreements and debt reduction, challenge and enforcement action, and most importantly, make an online credit, debit, PayPal, or Venmo payment with no fee. Lots of payment systems charge a $3 fee, and if you're making a payment every 2 weeks, that could be 26 $3 fees. So using the child support mobile app, you can make a payment without a fee being charged, which is very, very helpful. Now, I also want to call your attention to the New York City Department of Veterans Services, DVS, which helps vets connect to veteran services such as housing, education, and navigate other benefits available in New York City. You can click on that lozenge at the lower left for more information. And again, that will be sending you a copy of this presentation. So Veterans Services provides important services for vets in New York City. And there are also a host of other veterans resources. The VA, American AMVETS, Office of Mental Health, the Veteran Advocacy Project, Veterans Employment and Training Services, and the United War Veterans Council. And all these links will be clickable when you receive the presentation. So other important resources include the state and local child support websites. Now, I want to stress the debt reduction programs that we covered earlier, arrears cap, arrears credit. Those are all New York City programs. They are not available in the rest of New York State. They are not available in other states. As I mentioned earlier, child support is federally mandated, state supervised, and locally administered. So everything we've talked about today applies to cases that are based in New York City. And there are other resources listed on this page. Now, I want to stress an important legal resource is Family Legal Care. They're a nonprofit here in New York City. We work very closely with them. They have a helpline that gives family law information by phone, live chat, and email in English and in Spanish. They can provide legal consultations under certain circumstances for family law help. And they have tech hubs that can provide you with a computer and internet access if that's needed. Family legal care is an important part of the resources available for families in New York City and other parts of the state. Okay, Family Legal Care is also doing a live presentation next Monday, November 10th, on family law in the military, covering the rights and obligations of military and veteran parents in New York Family Court. And that is an Instagram live event that will help you learn about general protections for military members, how deployment can affect custody, how different forms of income for service members are counted as income for child support, and more. So we hope you will take advantage of this opportunity and tune in to the Instagram live presentation, Family Law in the Military, next Monday at 12:30 p.m. I believe it will be recorded as well. Now, that brings us to the end of today's presentation. Thank you very much for attending.